Good morning, everyone. Welcome back from the break. I'm Laura Grossman. I'm Associate General Counsel at the Investment Advisor Association, and I'm very happy to be the moderator for this breakout session on Compliance 101. I'm excited about this topic. It's not one we have typically done in recent years, but we thought that there was a critical mass of people who were either new or newish to compliance or have switched roles within their firms and would appreciate sort of going back to basics and just getting some tips on how to get a handle on this whole compliance job, this compliance industry. So let me start by introducing our terrific panel. I'm actually going to start on the end over there. That's Bob Plaze, who many of you probably know. Bob is a partner at Proskauer here in DC. And before he went to private practice, he spent almost 30 years at the SEC, where he had a hand in many of the policies and regulations that we all know. And I'd say he was the architect of the compliance program rule. So it's great that he's here and can really give us some insights into what the thinking was and what expectations are. And next we have Claire Burke. Claire is CCO of Vanguard Advisors. She's been there for over a decade. She made the switch from legal to compliance about 4 years ago. So we're interested in hearing Claire's perspective. And then we have Jim Prescott. Jim is at Ariel Investments. He's Vice President of Compliance. And he has a similar path, but he made the switch from operations to compliance also approximately 4 years ago. So we have a bit of a diverse set of perspectives here. I want to thank Bob, Claire, and Jim very much for being on this panel today. We're a relatively intimate group, so we do encourage you, just raise your hand if you have a comment or a question. We love to do that. We also will have someone collecting question cards if you care to ask questions that way. So just raise your card in the air and that'll get collected. So we're going to start with Bob and just back to basics, talking about the compliance program rule. Bob.
Thank you very much. Thank you, Laura, for inviting me to be with you this morning. I'm assuming that most people here are fairly new to compliance. I'd say, and I would count as fairly new to compliance, involved in compliance since entering compliance since 2003, which means the 21st century. Because before 2003, right there around, the landscape of compliance in the investment management industry looked very different than it is today. All of you are coming into the compliance area in a full-bloomed profession. When I first entered, began working at the SEC in the 1980s, I did an exam. I didn't do regular exams, but we went out occasionally. And the chief compliance officer of the company was a clerical person who had been promoted. And her principal job was to make sure that the ADV got filed every year, and the other filings. And I was a little astonished at the lack of resources of the organization. Well, they were running fairly simple organization, and everything was done on paper. There was still paper slips for orders and things like this. But it created quite an impression on me. And one of the goals of the compliance rule, 20647 that we'll talk about, was to create a professional compliance cadre within the industry. And as this conference indicates, and many of the people I know, including clients who are compliance professionals and chief compliance officers, are very, very high quality people who could be in legal or operational professions at the highest level, and have brought a new level of professionalism to the industry. And to that extent, I think it really has achieved a significance. Moreover, a number of my clients, the chief compliance officer is on the executive committee of the firm. And I don't know how many of you serve on that, but that's not required by the rule, and not even suggested by the rule. But firms have just made those decisions to include people. And finally, should I say, that the pay is much higher than it used to be, and there are a lot more jobs than there used to be. So you can complain about all this regulation, but at the end of the day, we're all benefit by it, including the investors, and that's after all what it was intended to do. We had some very serious compliance deficiencies back in this period when the rule came on board, the mutual fund industry had its first scandal, the late trading and market timing. The advisors to those funds and its executives were involved. These were not isolated individuals involved, and it was believed something more systemic approach to compliance was needed, and we developed the compliance rule. And in some respects, the framing of the compliance rule and the wording was borrowed, some concepts from the anti-money laundering. The provisions that were adopted had been adopted recently by the Treasury Department. That was in response, to you recall, to the Patriot Act in 9/11. So yes, you can trace the compliance rule in here right back to 9/11 if you really want to try. We were working on the money laundering rules. They had a chief money laundering officer, and they had policies and procedures reasonably designed to prevent money laundering. Whoa, that sounded good to me. And basically, some of the framework came from that rule. But let's go to 20647 right now. It really has just 3 parts. It's unlike the new rules they're writing these days, by the way. It could fit on half a page in normal text, word text. 3 points: adopt and implement written compliance policies and procedures. Compliance policies and procedures. These are a set of controls, basically. Management controls around compliance. And if any of you have an accounting background or accountants, understand what financial controls are. What set of controls and procedures and responsibilities are set forth within a company that can control the flow of cash and resources within in the company, so that we have with some degree of belief that the financial reports have integrity and that can be relied on by investors, and that management has the company under control. Those are financial controls designed for that purpose. These are designed to be compliance controls so that the management of the company, of the advisor, can reasonably believe that the company and its personnel are in compliance with the Advisors Act, which is the principal regulatory scheme in which this industry is subject to. And your investors can have confidence that you are in. And more importantly at the time, to me, the SEC can have confidence in the compliance. Adopt and implement written compliance policies and procedures. Firms had always done this. The larger, more developed firms had done this, but a lot of firms, see it fly by the night, seat of the pants operations. We used to do some examinations at the end of the year why somebody hadn't filed their Form ADV update in 6 years. Well, it turns out that Joe was responsible for doing that. And you know, Joe retired 6 years ago. Damn. I never knew what he did. And this would be the exam. And so compliance policy and procedure can be as simple as not Joe, but the person within the organization at the position that's responsible for doing some things like that. And so we would have compliance failures early in that as a result of a failure to an organization to build a set of controls, even if they hadn't been intending to violate the law. They had not done a set of controls to make sure that they lived up to the obligations. And as the obligations have gotten a bit more complex, the skill set required to do that is more important. And as the organizations have gotten much bigger, and Claire is here as proof of that from Vanguard, that when I began my career, the organizations were much smaller, and an advisor had like 15 or 16 people around 1/4 of one floor in a tower in Boston, and that was it. But we're much bigger now. Second, to appoint a chief compliance officer to administer these policies, somebody who's in charge of the compliance program. One of the things when we were thinking about this rule, we were surveying our examination staff in the regional offices where much of the real work gets done. Somebody in Chicago, I still remember it, said, you know, Bob, if we'd go in there, if they just had somebody in charge, that would be helpful. We go in there, and we try to figure it out, and they send us around, and nobody knows exactly. There is a program where they're in compliance, but no single individual has control of the compliance situations. And we evaluated, we saw the stronger firms are people that had somebody dedicated to that. Oftentimes, back then, that was in the legal staff, and sometimes it wasn't a legal staff. We're going to talk about that a little later. Somebody in charge. And for us and how it interfaces us, the SEC when I was there, and how that person is identified on the Form ADV, and now will be the focal point of contact between the organization and the SEC on a compliance exam. It's more than likely that that person will get the phone call saying that we're coming. That person will be the person who communicates with the SEC. All of my clients, we recommend that the Chief Compliance Officer sign the letters, sign the responses, handle communications, if for no other purpose than to let the SEC know that he or she is in charge, if not the whole organization, the compliance of the organization. And one of the things the SEC is doing implicitly in the examination is seeing the cut of the jib of the compliance officer and seeing what authority and what abilities that person has. Third, conduct an annual review of the effectiveness of those policies and procedures. Problem today we have and in the past is that you adopt it and then you forget it, right? And that happened. Now let's go into more detail. Adopt and implement. The form doesn't say how to adopt it. Whatever officer of the organization is authorized to adopt certain things and policies can do it. It doesn't have to be formal. There's no, unlike some other requirements of the commission, and implement. So it's not enough to adopt it. You have to implement. And there's a lot of implications that flow from those two words, and implement. The commission rule doesn't say what implement it means, but I can tell you, if you don't know, you need to know what it means. It means when you adopt a set of compliance and policies and procedures, they are internally your governing documents. And violation of those policies and procedures, or failure to follow your own policies and procedures, the SEC can bring an enforcement action under this rule as if you violated a provision or a rule under the Advisors Act, because they will choose you for violation of this rule. And so there's a lot of things that flow from that you've got to understand, or if you don't understand, you see happening in your organization, there's a reason, which means everybody's got to be subject to the compliance policies and procedures. You go to the Code of Ethics rule, you just have access persons, right, on those reporting. There's an exception, just access persons. Some organizations may choose to apply the securities reporting to everyone. There's no exemptions from the compliance program. Everybody has to be accepted from it. And if somebody's accepted from some provisions, you need to think about why that is and whether it's appropriately. Secondly, is that the compliance program has to be a living document and has to be meshed within the business processes of the organization and be consistent with the business operations of the organization. If the business is doing one thing and the compliance is doing another thing, you haven't really implemented those compliance policies and procedures. So a lot of compliance failures you see, the legitimate ones you see in the enforcement actions, it's a failure to implement the policies. They've got to be written, and they've got to be reasonably designed to prevent violations. And this is the squishy area of the rule, and the one that has been most troublesome in the enforcement area. Reasonably designed to prevent violation, that text there is designed to be reasonably designed before the violation occurs. Because afterwards, when there's a violation, you can always say, right, if I only had a policies and procedure that said, prevent George from stealing the petty cash. Or, you can always have a policy and procedure. It's got to be reasonably designed without the knowledge of the particular violation. And the difficulty the SEC and the industry has had the compliance program rule is this provision more than any other. Because there's always a temptation on the SEC to say, well, obviously your policies and procedures weren't reasonable or wouldn't have had the violation, right? But the industry is a part of the problem too, and lawyers, I can tell you, because it's always a temptation for members of the industry to settle to a compliance rule violation in order to avoid the, say, a fraud violation or violation of some of the other provisions. So you can't read the settlements and conclude that this is impossible, I should get out of this profession, because everything's a violation. I didn't have a policy and procedure. I can never have an adequate policies and procedures. They're settlements. You have to understand that. Yours should be evaluated by what is reasonable under the circumstances, and what industry best practices are with respect to a particular area should bear heavily in terms of what you choose to do and what the SEC chooses to consider as appropriate or not appropriate policies. Doesn't always work out that way, but it should. To prevent a violation, again, of the Advisors Act for it and its supervised people. Applies to everybody. Chief Compliance Officer, one individual, competent and knowledgeable. That's narrative. It's not in the rule text, but you see a number of enforcement actions, settled enforcement actions where the SEC makes observations about the lack of competency of the chief compliance. Not a lot. 4 or 5, 6 I can think of. You don't want to be on that side of it, but and neither does your firm. And if your firm can't pay the going rate for a competent compliance officer, that's a problem also. Empowered with full responsibility and authority. Didn't say it had to be an officer of the firm. How do you deal with a three-person firm with 3 partners? There are no officers, right? So we didn't do that. Instead, the release describes about the empowered with full responsibility and authority. What that means, basically, is you can scare people when your organization who aren't in compliance. It doesn't mean that you have supervisory responsibilities. And that's, we can talk about in my outline, the materials that gets into that more detailed. You're not their bosses.
So Bob, if you have an outsourced CCO, can they sufficiently scare people? Was that contemplated when you drafted this?
Well, no, the outsourcing was contemplated in the sense that we knew we had firms with multiple advisors with one CCO, and where that person was employed really didn't matter to us. That happens in the registered fund context. It happens in the hedge fund context. What we didn't contemplate when we were writing the rule is what the SEC sometimes call the rent-a-CCO, where you go to a third-party compliance consulting firm. And the observation I make in my outline, I put one together for the first time for this conference, I've always been meaning to, is the SEC will look dimly on that because they don't, it's not so much that the lack of authority, it's that they don't think you know what's going on in the firm, that you're removed from the firm and you show up once every week for a visit or so, or you get the securities reports and you look at from a distance, but yet you're not on the ground. You don't have a sense of what's going on. The SEC now has access to that information in the ADV. It asks a question of who pays you. They use that information in their risk matrix, considering a higher degree risk. They will come in and do an examination. That will be a feature of the examination, just testing the mettle of the CCO, just as it is in everyone. And in the course of the examination, you can either that CCO can either fulfill their dim suspicions, or you can prove it that it isn't. So an outside CCO very much can work in some organizations, and some has. Give me an example of the best kind. It's a firm that is largely a real estate firm, but it has a small advisory practice that it does as a sideline for some of the, say the proceeds of a sale. It advises how to handle the cash for short periods of time and manages around. And so it has to register as an investment advisor, right? But it can't justify a chief compliance officer. It can't justify training somebody with this, and so it will bring in a third-party CCO. I mean, it has to work in many organizations. In some organizations, people will push it. The other places it works is where the chief compliance officer quits one day, and now you've got an 8-week period where you're looking for a new chief compliance officer. A lot of times you can find a compliance firm, consulting firm, come in and take that position. You may have to name that individual as chief compliance officer for 8 weeks, but those are situations I think they have to be used. And so the SEC, even though they say nasty things, they've never done anything and said you can't do it. Let's go on to the fiduciary duty. One of the things the chief compliance officer is, if you're a lawyer and you've studied the securities law, you understand the fiduciary obligations. A chief compliance officer of an advisor, it's not like of a broker-dealer where you've got to master FINRA rules. You know every rule, you know every, and you've memorized them. You've gone to all these meetings. As a CCO of an investment advisor, you have to understand what being a fiduciary is. And these are subtle legal concepts in which there's a number of sources of information of this. It basically means is that you have an obligation to act in the best interest of your clients. means you take your salary, you take your fee, and everything else is for your client. An investment bank is how many touches there are, how many things you can sell to a client. An investment advisor takes its fee, takes its commission in some cases, but in this group, we're talking about an advisory fee primarily. And then you have an agency capacity, or fiduciary capacity, in which advice given to your clients should be in the client's best interest, and you should not subrogate those interests to your own interests. And that's sort of like the golden rule. Everything else flows from that golden rule. Of course, there's an exception, which has been discussed about, disclosure and consent. If you have conflicts of interest, if there's a duty of loyalty, which means you have to act in the best interest of the client and not yours, that can be addressed through a process called disclosure and consent. The brochure contains the disclosure, the client's acceptance of that brochure, or other forms of communication regarding conflicts and the implications of those conflicts on that relationship. You have to be able to understand that. And one of the rules of the road is that if you have disclosure, if you're relying on disclosure for consent, and if that disclosure is ambiguous in any way, because business has moved, right? Business has changed. Disclosure that was written last year, the question is, does it apply to this year or not? The assumption I make with clients, and I made when I was at the SEC, is that ambiguity goes against the advisor, because it is that disclosure that it creates a basis on which a finder of fact, and say an administrative law judge, can conclude that the client has understood the conflict and has agreed to the conflict and has consented to it. If there's ambiguity in that disclosure, more than likely than not, the SEC staff doing the examination or the finder of fact, if you're before an ALJ, will conclude there was not adequate consent. And it's your job, the Chief Compliance Officer, and when people want to do things that are not clearly disclosed, is to say stop, and to protect the franchise of your forum. There's ambiguity here. And all you have to do to cure that ambiguity, it's not like other regulated industry where you have to go to get approval from the regulator, or you have to get a shareholder vote or something like that, is all you have to do is to go out with supplemental disclosure to your clients explaining what this new conflict is, or to elaborate on that conflict and to obtain their consent, which you can rely on the passage of time. In fact, it's a little bit more complicated if you're a private equity firm. There's no liquidity event, but we're not focusing on there. So full disclosure of material facts, disclosure is your friend. The Commission will infer consent to a conflict. Suitability of advice, the broker-dealers, their standard is not based upon a disclosure and consent model. It is based upon a rulemaking model, suitability, principles of business principles, those models. And so the enforcement cases will look differently, will be framed differently, but both the NASD and the SEC can pick up an awful lot of the same bad actions on this. Finally, we've been talking about conflicts of interest, which deal with a duty of loyalty. There's also a duty of care. 95% of the SEC enforcement actions and deficiencies deal with conflicts of interest. 5% deal with the duty of care. And the duty of care has to do with showing up. It's an affirmative obligation. Duty of loyalty is a negative obligation. It's a duty not to do things. A duty of care is an affirmative to do things. A good example of an affirmative duty of care is a duty of best execution. You affirmatively have to go out and look for brokers who can best execute the trades for your client. A duty of care to vote proxies, as opposed to just leave them in the back room unopened. That's an example of a duty of care. The standards of the duty of care is typically referred to by the law of trust, an obligation to act as a reasonable person would do under like circumstances with similar obligations in the context of your engagement with your client. The duty of care, unlike the duty of loyalty, cannot be satisfied by the disclosure. You can't just simply disclose to somebody that, sorry, I didn't vote for those proxies. But however, the disclosure and your advisory contract can frame your duty of care. So to give you an example, if you have ongoing management responsibilities, you have a duty to engage with that portfolio and that client all the time. Say if you had an obligation, if instead you had a contract that obligated you to do quarterly rebalancing, well, then there's no obligation of care between those quarters. So the contract and your scope of your obligation can shape the duty of care. The duty of loyalty is shaped by disclosure. And these points that I'm making, I think were all made in the SEC's recent request for disclosure.
So it'll be interesting to see if the standards of conduct proposals, one part of which was an interpretation on the advisor's fiduciary duty, whether that gets adopted by the commission, and if so, whether it tweaks any of our understandings about what fiduciary duty means. So stay tuned for that. Before we leave this area, any questions about what we've discussed so far? Just an interesting tidbit, I was just looking back at the 2003 adopting release for the compliance rule, and you know how the SEC releases say to contact this person on the staff if you have questions. So the person named on that release is someone by the name of Hester Peirce. Of course, now SEC Commissioner. Bob and I were just joking whether she still has the same phone number and if you can call her about questions on the compliance rule.
She was my staff attorney at the time.
She worked for Bob. So let's switch gears a little bit now. I want to get Claire and Jim involved here. I kind of am interested in understanding, what do you wish you had known when you first started out in the compliance role? So let's start with Claire.
Sure. So, I've got a couple people from my team in here, and they've probably heard me joke about this in the past, but when I moved from Vanguard's legal department to Vanguard's compliance department, one of the biggest things that I noticed at first was that my son actually no longer understood my job. So I moved from being a senior counsel to being a senior compliance manager, and he started referring to me as a senior compliance blah, blah, blah. So that was sort of an immediate difference for me, but I think his level of confusion was not unique. And I will say not everyone who moves from a legal role to a compliance role does so within the same firm, and so not everyone will face necessarily the same challenges, but I think I experienced a lack of understanding among some of my internal clients as to how my role was different than what it used to be. And it was very important that I sort of established with the folks I had worked with previously that I was no longer a lawyer for the firm and what that meant. And specifically, depending on how you have your legal and compliance roles shaped at your firm, there certainly can be implications from an attorney-client privilege perspective to the change in your role that you need to be very aware of, and that you need your clients to be aware of. You may be working with the same folks who you worked with previously. They are used to coming to you for legal advice, and they are used to those types of questions being subject to privilege. For many compliance professionals, I would say most, that's probably no longer the case, and you need to make sure that your clients understand that. And understand that, if there is something that is particularly sensitive, it may be something that you need to pull folks in from the legal department. I think it's important that as a compliance professional, you understand that as well. I often am out looking for areas where we may have problems, where we may have gaps, where something may have gone wrong. And there is a deciding point to the extent that you do come across something as to when you might need to pull in one of your legal colleagues to direct an investigation or to help conduct an investigation. So that's certainly been a big change in roles that I had to adapt to. The other area that I would point out is, as a lawyer, I was used to interpreting laws and spending a lot of time on the analysis. I spend a lot more of my day-to-day now helping implement. Bob, you mentioned controls earlier, and I am much more focused on what the controls are that we have in place to prevent violations of laws than I was back in my legal role. That's not to say there's not a lot of overlap, because there is, and we work very closely with our legal colleagues, but it's a bit of a difference between deciding whether something is legal for the firm to do and deciding whether it's something that we can actually operationalize. and oversee. And so I spend a lot more time sort of in the weeds of the business, trying to understand the practical implications of things we want to do and whether that's something that we can both control and monitor.
Great. And Jim, how about you? So you switched from operations to compliance. What are some of the things you wish you had known?
Well, I did. You're correct. And I didn't go to law school. I'm not a CPA. I spent 30 years reconciling statements and in small firms and things like that. So it's very interesting for me, to be here with someone who's written the rules or a large firm like Vanguard. Most of my time was spent in firms, 20 people, $1 billion or less, doing the day-to-day work. So, over that time, I got to see a lot of problems come in. I went through 3 SEC exams during that time. I didn't really understand what was going on at first. Actually, I can tell you one time, one of my jobs was making sure everything got shred in the company. We had a lot of things. So, Wednesday was shredding day. So one of my assistants asked me, what do we need to do? And I said, well, why don't you go shred? So we went right next to where the SEC examiner was sitting and started shredding all right, like that, don't bother them, they're busy. I never thought anything of it. Well, they called me into a private office and wanted to know. They had a bag of my shredded material and wanted to know. So, I've come somewhat a little further from that. So I've learned not to shred in front of the SEC. However, the thing that really struck me once I made this transition, I had a lot of experience in the trading and operations, so obviously that's a big help. But I think about those of you out there who might be just brand new to the industry entirely. And I think about those of you who are managers who hire investment professionals into your firm who might be brand new. And what do you do to help them? What do you do to help yourself? And I think about that a lot, every day with myself. And the thing that kind of surprised me is just, in operations, I was an expert in what I did. I was very siloed. I knew these statements had to be reconciled by the state. The statements had to be sent out. If it was trading, they had to be allocated in this particular way, and there it was. Now I'm on the, cybersecurity. I'm supposed to know how to test on all these different areas of the company. That's difficult to adjust to, and I think just telling yourself it's okay not to be an expert on all this, and you don't have to go into the great depth that you need to, like you've learned to do in operations. Go ahead.
No, I'm sorry. But it seems to me that compliance requires essentially cross-training. If you want to use an athletic metaphor for this, that is, you could be just a lawyer, you just be an operations person, but to be an effective compliance official, you have to start off as a lawyer, you have to learn operations because you have to operationalize the law, and to be an operations person who goes into compliance, you have to learn the law.
You also have to be a psychologist.
Oh, okay.
Am I right? Do not intimidate people.
People skills.
People skills are so important. Socializing things, getting mentors, getting friends inside of different groups within the firm. And that was the strongest message I have is find a friend in accounting. Do everything you can, to be consistent with them. And, I certainly have found that to be a huge success and reach out. But
Yeah, and Bob, on your point about cross-training, I always tell folks that, compliance is a great field if you love to learn. I don't think there's a single day that goes by that I don't learn something new about either what we are doing at the firm, an area of the law. It is a profession where you are constantly growing and evolving. And so I think in many respects, it's an opportunity to continue to expand your own professional horizon, but it is an area where you often face discomfort as well because there is so much out there to know, and you're never going to know it all.
And Claire, you made a reference to making sure your client, meaning your internal client, your firm, understands your changing roles. And I want to ask Jim, so now that you're on the other side, working with the business side, what are some of the things that helped you start being an effective compliance professional and not viewed as the person who says no to everything?
Well, I have a boss who can say no to everything. So that, again, one of the strongest things that helped me is I have such a terrific culture of compliance and I realize that may not be the case in everyone's firm. So I can kind of play good cop, bad cop a little bit. But I'm learning how to be more of the bad cop. It's like being a parent, right? You can't always be the nice dad. And while I do have strong relationships within the firm, I've learned, that I have to be very careful about, how I speak to people. And when I ask something, just like being the bad debt, you say, I want this done, I want it done by this date. And if it's not, I have to take, action on it. And I try to cushion that by, making sure my follow-up skills are really strong. The other thing I've found that to be extremely helpful as a compliance person is when I set a meeting with people, I'm going to come and I'm going to talk to you about some testing that I'm going to do. I need to make sure that I'm very clear about why I'm asking this question, set an agenda at that meeting, and because I send a calendar out, and I make sure I show up on time, I ask those questions clearly, and don't apologize for not knowing what they do, but just ask these things and say, this is what it says in the procedures. I'm simply looking for evidence that it's been done. I want to help you find that evidence and suggest ways that it might look better.
So let's switch now to one of the core areas of compliance, which is annual reviews. And Bob, what are some insights you can give us there?
Well, one is that it can't be just annual. And it, in some ways, the rule is a misnomer, sorry. Because there's another part of the rule that says that they have to be effective, fully effective compliance procedures. And so effectiveness isn't measured once a year. It's not like your assets under management, Form ADV, or end of your fiscal year, once a year. And so the annual requirement interacts with the requirement that you have effective programs, and in which the SEC in the adopting release, and I haven't found a better way to suggest it to clients, gives 3 circumstances when you should concede, when you consider reviewing policies and procedures. What are the 3 circumstances? One is your own or industry compliance events. And say you have something that goes on, somebody did something, and it became a problem, a personnel problem perhaps, but you didn't really have a policy and procedure to cover it. That's a wake-up call that maybe we need to have a more formal procedure to deal with this. Or an industry event occurring, and this is the there but for the grace of God go I moment. When you read about an enforcement action involving something or about somebody doing something, you should think, could that happen here? And if it couldn't happen here, because we don't even do that, that's great. And so that's why you should read your monthly IAA newsletter. Reports on that, and other people's newsletters do too. And think about it. Is that an issue? Do we have that covered in our? That's such a great discipline. Second thing, of course, is that there's a new business arrangement in the firm that perhaps creates a conflict, or the new business unit has not been integrated in our unit that we've acquired, and therefore how our compliance policies and procedures need to change, or they need to change. Finally, if there's a change in the law and the rules. A couple of years ago, the Surface Transportation Act changed the requirements for disclosure of or delivery of the annual privacy notice. Who knew?
Better known as the FAST Act.
FAST Act. And your policies and procedures, well, it didn't have to, but it should have changed to accommodate that. So you've got to be aware. Another reason to get your quarterly, monthly newsletter from the IA, just to find out when things are changes. The annual report itself, there is no specification of who has to do it, but most policies and procedures identify the chief compliance officer is required to do it. Doesn't have to be done once a year. You need to touch on your significant areas at some time during the year. If you're a larger organization, Claire, I'm guessing you have a schedule over a 12-month period in which you cycle through your principal risk areas, and to some extent it's box ticking that you've actually done it, but another extent it's, and maybe you could explain, it's engaging with your business people at least once a year to see whether the policies and procedures continue to work, or whether the business people who own those policies and procedures are having trouble complying with it, or in some respects.
Yeah,
so
certainly those are ongoing discussions throughout the year around the effectiveness of our policies and procedures, whether processes are changing, how they are changing, whether anything needs to be updated. I think we also, as you know, other firms may do, change up what we do every year as well and how we do it. So We perform an annual risk assessment of our areas of focus every year, depending on where we land. And that risk assessment looks both at the operational risk as well as the regulatory risk. So going back to a lot of the factors you mentioned, Bob, around have there been enforcement actions? Was this an exam priority this year? But with the operational assessment, we also look at how has the business changed? How have policies and procedures changed? And depending on where we land from a risk perspective, we may take a heavier touch in certain areas than others from year to year, and we really use that risk assessment to drive how we go about our review of different areas impacting the advisor.
I can add that, yeah, we meet on a quarterly basis, our legal and compliance team, that's about 4 of us, and we find that to be probably the most, it usually goes about an hour, hour and a half, and it's one of the most productive and helpful tools that we have is our risk grid and operational. And we always go through step by step. We go through it. It's kind of dull. We'll skip over some, but we come in prepared, and we find that it's an amazing tool for us. And then when we do an annual check, our CCO goes out and is talking to the rest of the firm. It seems so second nature. So I would highly encourage you to do that.
Exercise. One last point. There's no requirement for a report, an annual report, but a number of firms, particularly larger firms, you're in the mutual fund area, there is a required report to the fund boards. But if you're not other than the mutual fund area, there's no requirement reports, although we have a number of clients that do provide a report to their executives. It usually starts out with a brief summary of the findings and an opinion expressed by the chief compliance officer that the controls are adequate. That requirement is sometimes imposed by management down as opposed to the chief compliance officer's idea. But I see these reports written that way and then goes through each of the touch points. Too importantly is there's the record-keeping requirements. You're required to keep any records that you create and do your annual report. So there's no creation requirement, there's a maintenance requirement. But OC doesn't seem to understand that, and so a part of every examination that I've seen has been a question for records. And the OC wants you to prove that you did the annual review, so just be prepared for it.
And on that documentation point, I can't emphasize that enough. It's going to be a little bit of a silly example, but when I first moved over to compliance, we had folks who would go out after we would file our ADV or file supplements, file amendments, who would go out and make sure that had actually been filed correctly and were posting correctly to the websites they should have been posting to. They weren't documenting the fact that they were doing that. And we said, let's make sure we've written that down. If you don't write it down, it's as if it didn't happen. And so it feels like something that's a little bit silly to be thinking about documenting, but I encourage you to think about the day-to-day activities that you are being performed that helps support the compliance program that you may want to document.
On the other hand, for smaller organizations, at some point that can be overwhelming. And so there's cost benefit here in terms of what's and put this in your policies and procedures. If you're a firm making those decisions of what to document and what not to document, or be specifically clear where you expect documentations if you can't document everything.
Jim, what are your views on that?
Well, I think that's where I get, maybe everyone would agree, or that's where I get the biggest eye rolls. Like, because my sentence I always use, can you provide evidence of, and then I get like that. And it's, but that's where I point to, I said, it says, this is what we do. So that's what I'm here to do, is check to make sure you're doing it.
That's true. And the downside, of course, specifying when you document, the failure to document is a failure to implement the policies and procedures, which is a violation, even though the documentation is not a requirement of law. I must say, I had a client recently, a smaller firm, that said they did their annual rule, but they didn't have any documentation. The SEC was all over them. I wrote them a letter back explaining what the rule says and what it doesn't say, and in the deficiency exam, it didn't appear. Maybe it's how you write that letter, but they weren't going to take us on that.
So I think compliance events, breaks, failures, whatever you call them, are inevitable. So what are some tips on how to manage those events and maybe even turn a bad event into a positive?
Well, I always think that if the SEC walks in and sees there's in your code of ethics, generally there's a requirement that you maintain a log of violations of the code of ethics. That's all it was intended to do. But the code of ethics also requires you to comply with the federal securities law. And so OC interprets that and has always interpreted it, is you've got to keep a log of violations of securities laws or your compliance policies and procedures or your code of ethics. And in every organization, there are human beings. In every organization, people make mistakes, and the SEC knows that. And if they come in and see a deficiency log or an exceptions log that is empty, they're just going to assume that you don't have a serious compliance program. So when you do have compliance deficiencies, and there's a scale from foot faults to, somebody committed grand larceny and different things you can do to deal with each of these, is to include them in that log and with a description of how they were addressed appropriately. And so you can use deficiencies that occurred during the course of your year between examinations in order to demonstrate to the SEC that you have an effective compliance program and that you take deficiencies seriously. And so that's why I think that creating that log, human beings, they're late on their securities reporting. There are also, I represent a large ETF group, and there are third-party service providers that make mistakes. They're excruciatingly technical mistakes, and sometimes there's a loss of money. And that service provider will provide a check to the fund for $386. That $386 reimbursement is noted. And so the SEC examiners goes through that. They like what they see. They like that the right people who are making the failures are reimbursing the investors, and you get good grades.
Claire, Jim, any anecdotes you can share with us from a friend or?
Well, certainly ideas like, trade errors comes to mind.
Yeah.
And the documentation of trade errors, and who does that, and to what level of detail do you write it? At the firm I was at, years and years ago, and it was, in the 80s or 90s, an error seemed to happen every day. We have this and there, and, we just write up a couple of things, and, we wouldn't get called on it. But when I got to Ariel, I was very impressed with the level of detail and care that went into not only, the CCO's, notification at the outset. The president's always notified no matter what the level of the error. The write-up is very thoughtful and extremely detailed because we know we're going to be asked very carefully what that is. Even if it's a $20 error, we're going to have that kind of detail. And most importantly, we're going to have the resolution and what changes we're going to make to prevent in the future. And when I test in an area, that's the first place I go to is look at what have we said we're going to do to correct things.
Jim, in terms of trade error, one of the important areas is in your policy procedures to define what an error is, because that is difficult sometimes. So if there is an order that is corrected before settlement and everything is unwound, so that no client's account is touched by that error, do you treat that as an error?
We do.
You do?
We have, it's surprised me actually because in other firms I had not done that.
Right.
So we have a number of write-ups like that. It's also interesting, we break out operational errors and make those separate from trading. We also have disclosure errors. If we're starting to find ourselves, doing write-ups and all kinds of different things and corrections that we're making. And, people don't like having to write things up, especially to the level that we're expecting it. But, we know that it helps, and it certainly helps for our audits.
I would think that, although you may have good reason to do that type of error, but I would think a policy that treats not as an error is one that is corrected and wiped clean before anything hits the accounts. It would not be trade error. It would not I would be comfortable with a client doing that. Although Vanguard, I'm not going to ask you what your policies and procedures are that, as I did him. But would you agree analytically that one could say that that's not a trade error?
It's not a trade error.
Okay.
Yeah.
But that doesn't mean that if you do it the way Ariel does it, that's not a good practice.
Claire, any further thoughts on managing compliance breaks?
No, I would just sort of reiterate, the benefit when the SEC comes in of having a thorough process in place. It makes exams go much more smoothly. If they can see everything in one package, there's much less follow-up, much less back and forth. And so I think I reiterate the importance there.
So you have a big job if you're a CCO or in compliance. So let's talk a little bit about the ability to maybe leverage some tools, maybe technology, the merits of paper versus electronic records. Claire, you want to kick us off?
Sure. I think firms have varying degrees of resources with respect to bringing in technology to help their compliance programs, and, we certainly recognize that. I would highlight, technology is not going to solve everything. And so I think, making sure that to the extent you do have dollars for technology, have prioritized where you will get the most bang for your buck by bringing that technology in, can be critical. I would also say, and to the extent you are able to bring in technology to help facilitate your compliance programs, making sure you've really thought through how you are going to implement that technology before you put it in place is critical. I think we, implemented a GRC tool a couple of years ago that has been beneficial to our compliance program, but we are having to go back now and take a look at sort of how we structured what we put into that tool to get a bigger bang for our buck. And for folks who aren't familiar, GRC is governance, risk, and compliance, and that's where we house our rules list that's applicable to all of our various compliance programs, our policies and procedures, our controls. It's where we house our inspection results. And so we've really had to go back and think about how we structured what we put into that tool. We always say sort of junk in, junk out. If you haven't really thought through how you want to use the tool and the benefits that you could derive from it, you may not get that bang for your buck. But I think, the overall message here is you don't have to leverage technology either. There are certainly, ways to have a very effective program without having technology solutions in place, depending on what the area is of your program you're talking about.
I agree. And I think maybe, well, first I'll mention that I think, the best spent money that we've put into technology recently is our, rules, regulations, or, reg tech, or, regulations technology on our trading system, particularly, managing our funds and things like diversification and, handling all the many aspects of a separately managed account edict that is very difficult to follow. I also think, thinking about smaller firms when I was back, probably your biggest tools are the really, really strong Excel users, which tend to be, in my company, the ones that had just got out of school about 2 years ago and have been working in banks or things like that, and come in and are really terrific at VLOOKUPs, pivot tables, writing out macros, doing that. I highly feel that, especially when you're doing trading surveillance, if you can get that trading file, which you're supposed to be able to do anyway, when the SEC walks in, they've got it, and they want it in that particular format, you should practice doing that, extract that information out for a set period, and run through those tests about what you're going to do. You're going to be doing that anyway, probably for your own testing, but things like that we do for checks on things like window dressing or whatnot. And I think that's really that I'd highly encourage anyone who starts in compliance these days is absolutely go back and get stronger and stronger as you can in Excel, and then leverage those people within your organization who are really good at it and get them to help you. And look at your project that you're working on, saying, how can I make this better? How can I extract this data? How can I compare better? How can I filter better? And I think Excel is probably the best tool that you've got in the whole box.
Yeah, when the SEC comes in and asks for your data and downloads it, you never want to be in a position where the SEC now knows more about your firm than you do. And doing exactly, Jim, what you said is that taking the same data sets that the SEC is going to ask for, which is your trading book, and filtering those out to see outliers the same way the SEC is going to be doing, and looking at execution questions and allocation questions. You want to be in a position when the SEC comes in that already know the answers, or if there was a problem, some in the organization, you'd already fixed it.
Practice it. Practice extracting that data and practice filtering through it and think, the scenarios, and use it for your testing.
Yeah, really basic tip. IA has a bunch of old exam requests that are available. I think taking a look at those exam requests and making sure that you know how you would extract the trade blotter data. And then, to the extent that you're able to do it, I think, firms can have varying sizes of trade blotters. Maybe you don't do a full 2-year period. Maybe you go in and say, let's see if we can pull a couple weeks, and go in, make sure we have the data elements we need make sure that the folks that we will be working with sort of understand what their roles and responsibilities will be with respect to that data extraction. And it's even a good time to talk through definitions. I know when we've had exams in the past, I've even got a question around, they say client name, what exactly does that mean? And some of these things you think are basic, it should be easy, but in the heat of the moment, it's not the best time to be trying to work through what exactly that means when you match it up with what's in your system.
Or
So,
maybe some data that you just can't pull. And you can go back to the SEC and ask them, is it really, beforehand, start asking that question. This is something that just really is not available to us, and it might be like a Bloomberg ticker or something like that. We use something different. Oh, okay, that's all right. The more basic information, of course, is necessary, but ask those questions. If not of the SEC, ask your colleagues. Reach out, ask those questions. Find your friends out in the firm within the same city. Call them up. There's a collegial atmosphere about compliance that I just love, because it certainly wasn't the same case in operations. So that's what we do.
So we received an audience question about document retention, and it says, with the increased use of electronic documents and cloud storage, what's the relevance and importance of paper documents now and going forward? Am I required to keep everything in a paper file, or is electronic retention preferred?
I've handled that recently for a client in a document destruction policy, which your firm, if it's of any size, should have. And that policy, part of your policies and procedures, should deal when documents are destroyed and gotten rid of. And in the context of that document retention policy, you have to define what a document is, which is that a document is retained if it is in paper form but scanned into a cloud system and a retention schedule kept there. But yet the electronic system is either kept forever if that's what you want, or at the end of the retention requirement is destroyed. So you have choices in terms of how you build your document destruction program and how you keep documents. You always keep it longer than you want to, but where it's that document destruction program policy where all these types of issues can be spelled out for the organization. Very important features of that policy. One is you have to need in that policy is what happens when you get a notice of an examination or a litigation and you have to put your document destruction program on hold immediately. Everything, because you don't know. Don't shred. Yeah. I was thinking, well, it was perfectly fine what you were doing if it was in accordance with the policy, and you could have showed them the policy and said you were doing. But it's still, The second thing which you need to do is to think about other aspects and laws that may require document retention. And I'm thinking specifically things that the Advisors Act, which generally is 5 or 6 years from last use. So it's a little complicated. But there are personnel laws under state law that may require documents essentially kept forever or as long for decades. So when you build your document destruction program, you've got to take into consideration not just the securities laws, but other state and local document retention requirements you may be subject to with respect to discrete portions of your documents.
We have a couple of extra minutes. Anyone have any questions for the panel? Yes.
ADV Part 2B, disclosure has been like one of the biggest things that the SEC is looking at. What processes do you guys have in place to ensure that advisors are actually delivering that ADV to their clients?
What I see is that the SEC, and they do it in 2A, so I haven't seen this in 2B, is that they will talk to clients about whether they will call clients and receive. And then my client, and this was just yesterday, came back with the emails that were sent to that client with the document attached to demonstrate the fact that the examiners found 6 clients who said they never received the brochure. We were able to come back with an email with their address on the email. This is a private equity client with not a huge number of clients, but that could demonstrate that. So that's one way. I mean, this was not planned. This client did not plan to demonstrate this way, but it was an effective. This was a response to a deficiency letter. So that's one example. If you retain all your emails, if your policy is to deliver it by email, which is common these days, and you retain all your emails, you can go into that archive.
and then, yeah, I was gonna say, I can ask.
For like that to be implemented in the operational process around like opening of new accounts and things like that, where you then electronically deliver it internally, like the firm will do it for the rep, so that way you ensure like the rep's risk of never doing it is not there. And the reason I say that is because, you know, you think about a rep, they just want to get the account open and like get everything going. So I'm just curious.
But this is a risk management system to some extent. There's no hard and fast rule on it. You have an obligation to deliver. The question is how you as a chief compliance officer develop policies and procedures to get to yourself to a level of satisfaction that that's happened. One way is you know, I mean, the ridiculous way is to require every client to verify, you know, like we do with the code of ethics. But another way is to say, do all of our clients accept electronic delivery? And if they do accept electronic delivery, you could deliver it by email, and that way you can keep a centralized record of that. I really should ask the
Yeah, I mean, we use electronic delivery for our clients who have opted in. I think it does, to the extent that you are able to implement that sort of system, I think it does provide a level of assurance that there's more consistency in the delivery. That being said, you know, there are clients who don't consent to electronic delivery. I think to the extent that you've got updates that are being made that maybe you haven't gotten uploaded into the system yet, you may at times have to do that manual delivery. So it's not completely fail-safe. I think you do want to make sure that your policies and procedures outline those situations when you may have to go outside of the system for delivery, because I think when you have it systematic, that's where you're probably going to have your failures, is when you're having to do the one-offs. And so I think making sure that it's very clear what happens in those circumstances is important.
And that's also for the rule, some testing. For instance, the SEC has the burden of showing that you failed to deliver, but you at the same time can show that you tested periodically. Not all of your reps, but rotationally. That will help you in terms of deal with that.
So we have come to the end of our time. Please join me in thanking Bob Plaze from Proskauer, Jim Prescott from Ariel, Claire Burke from Vanguard. Thank you for your participation.